Excuse me, I'm sorry about that. In plea bargaining, a defendant is faced with a charge at arraignment. Typically, this is the maximum charge or punishment that a defendant will be held to if he or she goes to trial. The prosecutors will present the defendant with an opportunity to plead guilty to a lesser charge or to the original charge with less than maximum sentence. A plea bargain allows the defendant to skip lengthy processes of a court trial and avoid being convicted of a possible stronger charge. There are three types of plea bargain available to defendants today. The three forms of plea bargaining are charge bargaining. This is used when a defendant pleads guilty to a less serious crime than the one originally imposed. Count bargaining. This is used when a defendant pleads guilty to a fewer number of charges. And sentence bargaining. This is used when a defendant pleads guilty knowing what sentence he or she will be given. When it comes to elements of a valid plea bargain, the validity of a plea bargain is dependent upon three essential components: knowing waiver of rights, voluntary waiver, and the factual basis to support the charges to which the defendant is pleading guilty. The role of a judge in a plea bargaining process is, in some jurisdictions, prosecutors and defendants can work with judges to determine what sentence the defendants will get if the defendant accepts a plea bargain. In most jurisdictions, however, judges' role in a plea bargaining is limited. For example, federal judges retain final authority over sentencing decisions and are not bound by prosecutors' recommendations, even if the recommendation is part of a plea bargain. Similarly, federal judges may not directly be involved in plea bargaining negotiations. I am in favor of continuing plea bargaining. For a defendant in a criminal case, plea bargaining provides the opportunity for a more lenient sentence than if convicted at trial, and to have fewer or less serious offenses listed on a criminal record. There is also the natural tendency to want to trade risk for certainty. This is especially true if you are being represented by an overworked public defender with little time to devote to the case. Therein lies the source of frequent criticism of the plea bargaining system. Some defendants, even if not actually guilty of the crime, will feel compelled to take a lighter sentence instead of asserting their constitutional right to a fair trial because they cannot afford a top-shelf legal defense. Additional attacks on plea bargaining focus on the alleged corrosiveness of the processes. This viewpoint characterizes plea bargaining as a series of threats and promises by legal officials that induce defendants to forfeit many of their legal rights and plead guilty. This coercion argument rests on the belief that defendants convicted at trial are sentenced more harshly than those convicted by plea. Since the defendant seeks to minimize his punishment, pleading guilty is made attractive by an explicit agreement or implication that his sentence will be reduced in exchange for a guilty plea. This promise convinces defendants that pleading guilty serves their own interests. This dual sentencing structure has been criticized because it penalizes defendants for exercising their constitutional guaranteed legal rights and subordinates due process concerns to crime control objectives. The most problematic aspect of plea bargaining occurs when a defendant is actually innocent of the crime but feels pressured to take a safer path and avoid the risk of trial. This is a dreadful situation, and it should be discussed carefully with an attorney beforehand. Some defendants enter a plea of no contest as a way to accept a plea bargain without admitting guilt. Ultimately, it is a decision of a person, and that person would have to make their own choice.